Part of our membership includes Judge Humphreys, a distinguished member of the court.
Extinguished, I think.
Extinguished, almost extinguished, yeah. And he's agreed to give us an update on what's going on with the Court of Appeals. And thank you. And it's all
Thank you,
yours.
Mr. Chairman. So if you were at the last meeting, you're aware that the commission advised the commission staff, I should say, advised everybody about the many phone calls they were getting from defense counsel and prosecutors all over the state regarding what they courts could or couldn't do with respect to probation violations in the wake of the 2021 amendments to the Code of Virginia. And I mentioned at that time a couple of cases that were in the pipeline in the Court of Appeals that I knew were due to be released in the very near future. Following that meeting, both those cases were decided pretty quickly after that, and I advised the chairman and Meredith about the outcome and sent them copies of the cases. And you know, based on the adage that no good deed goes unpunished, I was then asked to stand up here and make this presentation about the current state of the law with respect to the interpretation of the amendments to 19.2-306 and its progeny. I note that Delegate Adams and Senator Edwards, two legislators who I've known for a very long time, John Edwards and I go back probably 30, 35 years working together, and Delegate Adams and I have worked together on a number of things over the years. So it's interesting that this commission represents an intersection of all three branches of government. And dealing with probation violations also is an intersection of the judicial and the legislative branch. In fact, the previous presentation dealt with that as well. So when you're dealing with separation of powers issues, it can get a little tricky. And so with that, I'll point out that just as by way of a preamble, that probation generally and the right or the ability to suspend a sentence is not inherent authority of the courts. They're creatures of statute. Contrary to the publicly expressed statements of at least one judge in Northern Virginia, the courts have no inherent authority to suspend a sentence or impose any sort of probation. At common law, in fact, all the courts could do was to fix the punishment within whatever the statutory range was, and that was the end of it. New York in the 1890s was the first state to statutorily provide for an alternative means for rehabilitation that involved suspending sentences and providing for a probationary period, and Virginia followed suit. And the statute that Virginia enacted, and it's been around since prior to the current edition of the code, its current incarnation is 19.2-303, which I've highlighted the important parts there, but it basically gives the courts the authority to suspend a sentence in whole or in part and place a defendant on probation under such conditions as the court may determine. And then also the court can fix the period of probation up to the statutory maximum for which the defendant might have been originally sentenced. And they also with the 2021 amendment, they placed a limitation of 5 years on supervised probation. So the court is limited to placing a defendant on supervised probation for no more than 5 years. So that was the longstanding language that in the code, except for that last sentence I just read. And again, in 306A, and I'll get to I've highlighted the subsection A there because we get to the subsection C. It contradicts this a little bit. But again, the General Assembly affirmatively gave the courts the authority to revoke the suspension of a sentence for any cause that the court deemed sufficient that occurred at any time within the probationary period or within the period of suspension fixed by the court. And by the way, just as an aside, those are two different concepts. I think we tend to align them together, but a period of suspension and a period of probation are not necessarily congruent. Then in 2021, with the amendments that they made to the probation statutes, the General Assembly added this subsection C, which kind of modifies and conflicts arguably with subsection A, because subsection C says the court, after hearing, if the court finds good cause to believe the defendant has violated the terms of suspension, then the court may revoke the suspension and impose a sentence in accordance with the provisions of 19.2.306.1. So basically, In 306A, the General Assembly has told the courts that you can revoke somebody for any reason you deem appropriate. But then in 306C, they said, well, wait a minute, but look at 306.1, and that places some limitations on what you can do there. Well, 306.1A says this, and I'm not going to read all this, but it defines technical violations. And there are 10 defined courses of conduct, if you will, that are defined as technical violations. And I've summarized them here. It's essentially failure to report a new arrest, failure to maintain employment, failure to report within 3 days of release from incarceration, and that it means report to your probation officer, failure to permit a home visit by a probation officer, failure to follow the instructions of the probation officer or be truthful and cooperative with them, refrain from the use of alcohol if it interferes with employment. And that last phrase I'm emphasizing because we're going to circle back to it with a case that the court decided recently. And then also refrain from use, possession, or distribution of controlled substances, refrain from ownership, possession, or use of a firearm, get permission from the probation officer to change your residence, or just outright maintain contact with them. So if you do any of those things, that is defined as a technical violation. Now, the statute also goes on to say that if you've done more than one of those things, or maybe all 10, maybe you were put on probation by the court and you never did anything, you never showed up, you never reported, you never, you just took off somewhere. That is, by statute now, a single violation. And it's prospective as of July 1st, 2021, because that's the effective date of the statute. So anything that occurred prior to July 1st, 2021, any probation violations that are hanging around in the courts post that are under the old statute, and any conduct since then is going to be governed by the amendments here. The statute then provides for limitations on what the court can do if the conduct of the defendant meets one of those 10 definitions of a technical violation. For the first one, the court can literally do nothing. Well, not nothing. They can, speak sternly to them, I guess, but they can't impose any of the suspended sentence. For the second offense, they can impose up to 14 days, but there is a rebuttable presumption against even doing that. It isn't until you get to your third or subsequent technical violations that all bets are off, and the court can do whatever it wants to within whatever the period of suspension, however much time has been suspended. So that's the clear legislative intent that's expressed with respect to technical violations, and that hasn't been, other than, and by the way, the courts are very careful, at least the appellate courts are very careful to defer policy considerations to the General Assembly, whether we may personally like them or not. So we do go out of our way to try and interpret what they mean, and sometimes they make it easy, and sometimes they don't. And I think this is one of those times when they really didn't very well. Again, 306.1b, this is the one between A and C that I just mentioned, has this language. If the court finds the basis of a violation is that they violated another condition other than a technical violation or a good conduct violation, I'm going to get back to good conduct in a second, that did not result in a criminal conviction, then the court may impose any or all of the suspended sentence, basically. So that language, other than a technical violation or a good conduct violation that did not result in a criminal conviction, has been the subject of most of the debate since this statute became effective. So it's pretty clear, and it always has been, that if you commit a new crime and you're convicted of a new crime while you're on probation, that's a clear-cut violation to your probation, and the court can do whatever it deems appropriate with respect to whatever balance of the suspended sentence there might be. You can put you on a new period of probation. They can execute all or any portion of the suspended sentence and do whatever basically the court wants to do within the range of the statute itself, the punishment statute itself. However, the two question marks that the statute kind of left hanging out there was, what in the world is a good conduct violation? And also, what about special conditions? And when I say the word special condition, it's not defined, neither of them, by the way, are defined in the code, but the commonly understood definition of a special condition is a condition other than the ones that are routinely imposed, those 10 that I listed that are routinely imposed on all probationers by the Probation and Parole Office, the Department of Corrections, and are either imposed by the court or by a probation officer pursuant to statute or some other authorization. So that's where the tension has been with respect to the appellate courts wrestling with this stuff. So starting with whatever a good conduct violation is, there are a number of what we call them canons of statutory construction that courts use to try to discern what do the General Assembly, what do the legislature mean when they say certain things. Usually they make it pretty easy because they either define their terms in the statute or they use terms that are commonly understood, or in this case, they might have used terms that are used elsewhere in the code that have a defined meaning. One of the problems here is that good conduct is not defined in the code anywhere, and it's only used in one place in the code elsewhere, and that's in the title that deals with the Department of Corrections, and it relates to good conduct credits that inmates can earn while incarcerated, which has, of course, nothing whatever to do with probation and parole, and certainly wouldn't seem to fit anywhere in this legislative scheme. And then, of course, special condition that's not defined either. What is it? We think we know what it is, but again, it's not defined. Did the General Assembly mean something different, or do they understand it to mean what the courts have been doing for a long time? This brings us into the separation of powers doctrine because, as I mentioned, probation is purely a creature of statute. The courts have no inherent authority to do anything with respect to probation unless it's authorized by the legislature. However, courts do have inherent authority to enforce their own court orders. That's the contempt power the courts have had historically. So this is kind of an area where they kind of bleed together when the court issues an order, and that order includes some things that the General Assembly has either authorized or not authorized, and what happens then. And what about conditions of probation that are set by the Department of Corrections or by the probation officer, individually? And can a court delegate any of its authority with respect to probation conditions to the probation and parole officer? Those are all questions that the courts have been wrestling with, and we're starting to answer them. And that's what we're going to be talking about now, is the answers that we have so far. Well, with respect to that last point, it's been the law since 2016, in this case, Wilson versus Conwell. Circuit courts may not delegate to probation officers responsibilities that are the sole province of the circuit courts. In this case, what happened was there was a situation involving restitution, and the court, neither the Commonwealth nor the defense apparently could agree on what the amount of restitution was. And of course, you may be aware there's a statute that requires courts to impose at least partial restitution as a condition of any suspended sentence. And what the court did was simply delegate to the probation officer, you basically figure out what the amount of restitution is and make that a condition of their probation. The problem with that is the statute very clearly and very expressly says the court shall determine what amount of restitution is owed or should be paid as a condition of a suspended sentence. And so my court held in Wilson that the courts, because the legislature was specific in assigning that responsibility to the court as opposed to the executive branch in the form of the Department of Corrections or the probation officer, that only the court had the authority to determine the amount of restitution. I think that logic applies to any other statute that where the responsibility is directly given to the court. DeLon is a more recent case since the statute became implemented. And in DeLon, what happened was there was a situation where, and this was a case that the new statute did apply to, the court made a special condition one of the courses of conduct that the legislature defined as a technical violation. But the court imposed it as a special condition. So you have a court order saying, do this, and a And if you don't, you run the risk of having me, the judge, execute some or all of your suspended sentence. And on the other hand, you got the legislature saying that's only a technical violation, and so if it's the first offense, they can't do anything, and if it's the second offense, maybe 14 days at the most, and so forth. And in DeLon, my court held that basically, the legislature defined these things as a technical violation and specifically limited what you could do. So it matters not that the court also made it a special condition. Therefore, basically the legislative language trumps the fact that this was part of a court order, basically incorporated into an order of the court as opposed to just a requirement of the Probation and Parole Office. I will say as an aside that I found out this morning that the Supreme Court of Virginia granted a writ in this case last week. And so this will be heard, I guess, in September, I think is their next sitting. So the Supreme Court will hear this case. So stay tuned on this one. I guess we'll have more to say on this subject after September, or whenever the Supreme Court releases its opinion. Hart came along shortly after DeLon. And in Hart, the question was, well, all this conduct that constitutes a technical violation, what if some of it occurred prior to the effective date of the statute and some of it occurred after the effective date of the statute? Does that count as one technical in other words, how do you do the math on that? And the answer with Hart is, well, basically the definition of a technical violation is a technical violation preceded by two prior technical violations, or one prior, depending on how many you're looking at. So in other words, as I mentioned earlier, the statute requires sort of the amalgamation of conduct for each violation hearing, but the number of violation hearings basically is what's going to trigger which part of the statute the court has the authority to use to either execute or not execute a portion of the suspended sentence. I think this is also before the Supreme Court, but they have not acted on this yet, and I'm not sure whether, I have no intelligence about whether or not they will or not, so we'll just have to see. And then this case, I was involved in this case, I wrote the opinion in this case, and what happened here was basically you had a situation where the defendant had all kinds of previous problems, and the issue was really, okay, how do we parse the statute, determine what the court can do, what's good conduct? The argument was that the defendant had violated the Commonwealth's argument was the defendant had violated a special condition. The defense argument was basically that no, it's true, it was a special condition imposed by the court, but it was the court didn't really have the authority to do anything with that despite that. So this was the effort by the court to really take the statute and parse it out sort of piece by piece. And so we started here with actually quoting from the statute, which is typically what we do whenever we do any sort of legislative interpretation exercise. You start with the language of the statute, and I won't repeat it, it's up there. But then what's a good conduct violation? Well, as I mentioned, good conduct is only used in one other place in the code, and that's with respect to good conduct credits. It wasn't defined by the legislature. However, the courts for the last 50 years or more have used the phrase good behavior, and good behavior is well understood as a phrase or a term of art within the court system here in Virginia, and it has been defined by the Supreme Court as, quote, substantial misconduct, whatever that is. And so arguably, if previously at least, if a defendant was guilty of substantial misconduct, whether or not it resulted in a criminal conviction, that arguably was a violation of their probation or their suspended sentence. However, this General Assembly ignored the phrase good behavior, which is well understood, and used the phrase good conduct. Well, the problem with that is that there's a canon of statutory construction that when the General Assembly uses a particular term or phrase that's different from what is used otherwise, they mean something different. So Arguably, the General Assembly meant something different from good conduct, excuse me, from good behavior by using the phrase good conduct, but we didn't know what the heck it was. So typically what happens is you either look at the code, and I already mentioned that exercise where we looked at the code and found the only other reference to it was in with respect to good conduct credit, so that was no help. So then typically what you do is you look at the commonly understood meaning of the term, which means you let your fingers do the walking to Webster's dictionary, and you look it up, and you come up with basically good behavior equals substantial misconduct, and good conduct equals good behavior. Because basically, if you look at the dictionary definition, you cannot distinguish the term conduct and behavior. So misconduct and bad behavior are basically synonymous. And so that's what we held in Diaz-Urrutia. I did put this language in there in green, and with all due respect to Senator Edwards and Delegate Miles, for whatever reason the General Assembly may have had, the application of commonly used principles the courts of the Commonwealth use to construe statutes render it difficult to avoid an absurd result in discerning the legislative intent from the language of this statute. So maybe they'll clarify that at some point. Hint, 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 Senator and Delegate. But it would be helpful if the courts had some guidance in this area. However, for now at least, we're equating the two for whatever that means. Again, maybe the Supreme Court will take this case and tell us something different. Now, so let's go back then, and given that, how does that play into the language of the statute? Well, again, the plain language of the statute refers to another condition other than a good conduct violation that does not result in a criminal conviction or a technical violation. So other than those, essentially, the court can do whatever it wants. So that was the way we parsed the statute to determine that essentially if, we also pointed out that basically the 10 courses of conduct that are basically prohibited or required, maybe is a better way to put it, that are now defined as technical violations, are all conditions imposed on all probationers routinely by the Department of Corrections, essentially. Whereas special conditions can be imposed by either the court or by probation and parole, or perhaps, the interstate compact, some other group that has authorization, statutory authorization to do so. Again, in parsing separation of powers, we defer to the legislature within their area, which here deals with the conditions of probation and parole, whereas enforcing court orders is inherent with the court, but where the court order is simply implements a legislative requirement, then they have to be guided by the legislative direction. So that's kind of the way we kind of worked that out and came up with this four-part test in Diaz-Urrutia. So step one is to determine whether the violation conduct matches any of the conduct that is defined as a technical violation. So that's the first thing. And basically, if it does, stop, do not pass go, do not collect $200. Basically, it's a technical violation, and you're done, and you can only do whatever the court permits you to do, depending on whether it's the first, second, or subsequent, third or subsequent technical violation. However, if the answer to that is no, then step two is then does the conduct match any other condition of probation, whether it's imposed by the court or by probation and parole. And if the answer is that it doesn't, then is it a good conduct violation slash good behavior, because they're now basically synonymous. If the answer to those are both no, then the court can do nothing, because there's been no violation, basically, if it's not a technical violation. But if the answer to either one of those questions is yes, then the court can proceed to impose any sentence or execute any portion of the suspended sentence it deems appropriate. But if it, in fact, is a good conduct slash good behavior violation, then stay tuned, because we don't know yet. We don't know what the penalty, if any, there is. Arguably, there's none. You can look at the statute and make a really good faith argument, if you will, that if it's substantial misconduct, but it is not a new criminal conviction, there's nothing the court can do. Now, that may be an oversight. I suspect it was. I seriously doubt that was the intent of the General Assembly, but, you know, I was not elected to that body. I was elected to a different body, so that's not my call. So that's theirs. Now, Thomas, which is the most recent case out of our court, decided about a month ago, a little over a month ago, deals with a situation where we had a sex offender, and sex offenders have particular requirements that are authorized by statute for the probation and parole department, or the court for that matter, to impose. And this was one of those situations. And one of those was the requirement that the defendant abstain from the use of alcohol. And he didn't, and he was violated. And so the question here was, well, okay, is that a special condition, or is it good behavior? I mean, it certainly didn't result in a new criminal conviction. But it was imposed by the probation officer as opposed to the court. Does that matter? The answer is that it doesn't. You know, it was authorized by the legislature, particular for sex offenders. The probation and parole officer exercised their authority to place that condition upon them. It was not, my court held that it was not neither a good conduct situation or a technical violation, because it didn't fall into if you recall, the technical violation with respect to the use of alcohol has to interfere with your employment. This was just a general bar on the use of alcohol by sex offenders. So the court came to the conclusion that essentially it seems kind of counterintuitive that and the case was, by the way, remanded because the court found that the trial court was correct in considering the use of alcohol to be a special condition as opposed to a technical violation, but the use of the drugs was a technical violation and not a, so basically you're penalizing the use of alcohol but not the use of drugs, which seems to be kind of a counterintuitive situation, but it's the result of parsing the statute the way we have to do it. So hopefully the General Assembly will at some point maybe fix this and give us better guidance on it. But meantime, we'll try to muddle through it. I'll be glad to answer any questions anybody might have about it. I hope that was, yeah, Chip?
I haven't seen any come up through the court about the 5-year limitation. Have you all seen anything on that as to, you know, someone was put on for 10 years before, and how does that 5-year get calculated? Is that?
Well, we haven't, there's no cases deciding that issue, but I will say I have seen cases where we have, with per curiam unpublished opinions, affirmed situations where the court imposed more than 5 years, but the violation occurred prior to the effective date of the statute. So it was not retroactive, basically, if that helps.